Hi, I'm divorce and family law attorney Kyle Scoresby. I'm making this video to address a topic I call double dipping. Sometimes in a divorce case, you'll have a self-employed spouse and they make pretty good money, and their spouse is trying to seek spousal maintenance from them and get a portion of their business. We have to be very careful if we're representing the self-employed spouse that our client doesn't get hit twice for the same thing. We don't want to have to compensate the opposing party twice, once in the form of dividing up a business with them and a second time in the form of spousal maintenance. I'm going to try to illustrate this using a little visual aid I've made. We're going to use as an example a person that has, this is kind of a sexist stereotypical example, I realize, but a guy who has a plumbing business. And let's say his total income from this business is $150,000, the top line on my chart here. And for him to hire somebody to replace himself so he could be a totally passive business owner, that would cost him $100,000. That means that business has excess earnings of $50,000. So in other words, the business owner can generate profit of $50,000 even if they stop working the business. That $50,000 is sort of the magic profit piece that gives a business value, aside from equipment and so on. So if a business is valued by a business appraiser and then taken into account in the division of assets, and the spouse gets compensated for it, they've essentially been compensated for that excess earnings piece already. That's taken into account in the value of the business. So when the spousal maintenance calculation is done, that should be based only on the fair market earnings, not on the whole spectrum of income, not on the whole 150,000. If you based the spousal maintenance on the whole 150,000, the spouse would be double compensated for that extra 50,000. So again, in this example, the 50,000 excess earnings, the spouse is compensated for that in the division of assets. But spousal maintenance should be solely based on the fair market earnings. So, and we usually need an expert witness to go to court with us on this to help us prove these points. But if this is your situation and applies to you, you've got to talk to an attorney that understands this distinction so we can protect you in that process.